Thank you, Kimball. I'm Ryan Parker. I'm the Vice President of Product Development at 650, and I'll be one of the co-presenters for our webinar today, along with Marie Colbeth, who is our General Counsel at 650 and is also the Co-Director of Law X at BYU Law School, and our Director of Legal Product, Adrian Jack. And so the three of us have divided up the different parts of the ETS, and we're going to talk about that today. Let me give you a brief roadmap of what our presentation is going to look like. We'll start with some general information about the ETS, how it was passed, who it covers, what it does, and then we'll drill in a little bit more detail about what's required of businesses, and we'll look at some of the specific requirements. Then we'll take some time to look at the way that Cal OSHA is enforcing COVID-related regulations, and we'll talk a little about potential enforcement regarding these temporary standards. And then we'll take just a moment to look at potential solutions and ways that businesses can try to comply with these ETSs, including a brief overview of the solution that we've created here at 650 to help our customers to comply with these new emergency temporary standards. We would welcome any questions that you have, and I think Marie just put this into the chat, but if you have questions, feel free to put them into the Q&A using the Q&A button at the bottom of the screen, and we will try to answer those as they come in to the extent that we can, especially if they relate to topics that we're discussing during the webinar. And then we will also have a question and answer portion of the webinar at the end, where we'll get to any questions that we didn't get to during the webinar, and we'll be happy to take other questions to the extent that we can. As Jesse mentioned earlier, I believe in the chat, we have slides that we're going to be using to present information, and we'll be providing those slides to you by email after the webinar. And in addition, we'd be happy to answer any questions. And so without further ado, I'm going to turn the time over to Adrian, who's going to present the first part of our webinar.
Thank you, Ryan. This November, the California Division of Occupational Safety and Health, which we all refer to Cal OSHA, drafted standards relating to COVID-19 prevention in the workplace. And then on November 20th, the Occupational Safety and Health Standards Board, which is the 7-member standard setting agency within the Cal OSHA program, unanimously adopted these emergency temporary standards, which we refer to as the ETS throughout this webinar. 10 days later, the Office of Administrative Law approved the emergency temporary standards, and they went into effect immediately that same day. These standards are effective for 180 days right now, and they can be reapproved for longer periods. They can be readopted for additional 90-day periods if the standards board requests a readoption. So we'll be living with these emergency temporary standards at least until the end of May next year. And as we'll talk about next, these standards apply to almost every employer, and they are broad and expansive and have a lot of requirements that apply to California companies. So these standards can also become permanent if the standards board approves them through the traditional rulemaking process, but right now they're temporary and set to expire at the end of May next year. So these are the 5 new additions to the Title 8 of the California Code as a result of the ETS. So we have Section 3205, which relates to COVID prevention, and then 4 subparts of that section. So 3205.1, which relates to multiple COVID infections and COVID-19 outbreaks, and that's a defined term we'll talk about later. Section 32052 talks about major COVID-19 outbreaks, another defined term. Section 32053 is COVID prevention for employer-provided housing. And Section 32054, which is COVID prevention in employer-provided transportation to and from work. And in this webinar, we are not going to talk about 32053 or 4, which are COVID prevention for employers that provide housing or transportation. Those are important to certain industries, but we wanted to make this webinar applicable to most employers. And so just know if you are in those industries where you provide either transportation or housing, that there are certain requirements within Section 3205 that you need to focus on, even though we won't be addressing them today in this webinar. So these emergency temporary standards apply to all employees and places of employment with 3 exceptions. The first exception is workplaces where there's only one employee and that employee does not have contact with other people. The second exception is employees who are working from home. And this exception only applies as long as those employees are working from home. So if your company plans to transition employees back to the workplace anytime at the beginning of next year, these standards might not apply right now, but you should be thinking about how are we preparing to comply with these standards as soon as one employee goes back to the workplace. These standards will apply to your company. And it also applies to employees who are exposed at work, but then work from home. So even though they might not be working in the workplace at that time, if it's a result of an exposure from work, these standards still apply to that employee. And the third exception is employees who are covered by Cal OSHA's aerosol transmissible diseases regulation. And there are certain facilities and employers such as healthcare facilities, labs, where these that are already governed by a different section of OSHA requirements. So the ETS does not apply if those employees are already complying with with that particular Cal OSHA requirement. So as you'll see, these are expansive and cover a lot of companies, pretty much all companies, as soon as they transition any employees back to the workplace. So if the ETS applies, then what are the requirements? So the ETS requires covered employees to establish, implement, and maintain an effective written COVID-19 prevention program, which we call a CPP. And so that CPP can be integrated into the employer's existing injury and illness prevention program already required by OSHA, the IIPP, or it can be maintained in a separate document. But either way, it has to meet all of these requirements, some of which are already included in the IIPP, which makes it additionally confusing for companies to sift through and see what do we already have in our documentation, what are we missing, but companies do need to have each requirement listed here, which is the identification and evaluation of COVID-19 hazards, investigation and responding to COVID-19 cases in the workplace, the correction of COVID-19 hazards, training and instruction, physical distancing, face coverings, other engineering controls, administrative controls, and personal protective equipment, reporting, record keeping, and access information, exclusion of certain COVID-19 cases, and the return to work criteria. And the company has to include all this information and then additionally have a system of communicating most of this information to employees. And we'll talk about most of these requirements in depth later. So some of these requirements may sound familiar to Assembly Bill 685, which was signed in September of this year. AB 685 becomes effective this coming January and is in effect for 2 years, so until January 1, 2023. And AB 685 has some similarities to the new ETS, and so we want to highlight that some of these requirements are similar, but there are a lot of new additional requirements in the ETS, and there are also some differences that companies need to note. So even though you might think you're complying with AB 685, there are new requirements and some different requirements in each of the different regulations. So some of the highlights of AB 685 are that employers must provide written notice within 1 business day to all employees, those employees' authorized representative, and employers of subcontracted employees at the same work site of the infected individual within the infectious period. Employers must also notify local health departments of all workplace outbreaks. And then AB 685 also allows Cal OSHA to issue an order prohibiting use or shut down an entire work site or workplace area that exposes employees to an imminent hazard related to COVID-19. Additionally, Cal OSHA can issue citations for serious violations, which we'll talk about later in this webinar, relating to COVID-19 without giving employees a 15-day notice, which was previously required to issue a serious violation. And so part of 685 weaponizes this new ETS that allows Cal OSHA to issue more severe citations as well as issue them more quickly. And so that makes the ETS of additional importance because it's effective now and the penalties are enforceable now and they are severe. And so we'll talk about those penalties later in the webinar. But just be aware that AB 685 and the ETS relate in certain ways, and the AB 685 makes the ETS in some ways more enforceable. A couple of the similarities and differences between the ETS and AB 685, and we could do a whole webinar on AB 685, but just wanted to highlight for you that these standards are new. Some of them are already in AB 685, but some of them aren't, and some of the standards are different under each of the laws. So both of these laws require notification of exposure to affected employees within 1 business day. And then also both require providing information about benefits provided to COVID-19 affected employees. So those are 2 similarities under the 2 laws, but there are a couple differences that matter to companies. First of all, AB 685 requires employers give notice to employees at the work site, at the same work site as the infected individual during the affected period. So that requires them to give broad notice to anybody at the work site that entire day with somebody who has COVID-19. Whereas the ETS only requires notice to affected employees. So AB 685 requires notice to the entire work site, while the new ETS only requires notice to the specific employees that may have had contact or exposure to an infected employee. So that notice is different. And AB 685 requires that notice to be written in both English and the language employees, that the majority of the employees understand, whereas the ETS only requires that employees give notice. So there are 2 conflicting standards under both of these laws. One requires written notice to the entire workforce, the other just requires notice to affected employees. So companies might be struggling to comply with both of these, but just be aware there's 2 different standards. And also AB 685 requires that companies provide notice to the unions of infected employees, and the ETS does not have that similar requirement. There are some differences also in the notification to the health department. The AB 685 has a list of 7 or 8 requirements that the company has to, certain pieces of information a company has to provide to the health department in relation to an outbreak at the work site. And then the ETS has those same 7 or 8 requirements plus 2 additional more requirements. So be aware the standards are different and they require a close read to make sure that companies are complying. I'm going to turn it over to Ryan to talk about some of the specifics of the CPP.
Thank you, Adrian. Before I start, there was an interesting question that I thought related to your presentation. Maybe we could take that now. One of our attendees asked, do the ETS apply to employees who only go into the office periodically without others present at the same time? For example, to check mail or just go in from time to time. I think that this could be a situation that a lot of businesses have where they're not actually letting people into the office, but periodically someone needs to go in to pick up mail or packages or check on things at the office. What do you think about that question, Adrian?
Yeah, that's a great question. And I think that this is a new standard we don't have a lot of guidance on, but based on what we know so far, it seems like that company would be subject to the ETS because that company has more than 1 employee, so it doesn't fit under the first exception. And because even though there's only 1 employee going in per time, and that employee is at the workplace. So it sounds like the safest route right now would be for that company to comply with the ETS, but this is a new law that's unfolding that might have some unique exceptions and guidance, but I think the safest situation right now is for that company to comply.
Thank you, Adrian. And Adrian makes a great point there. In this regulation, there is some ambiguity. There are some terms that we're still waiting to learn more about. Cal OSHA has put out some Q&As where it's provided some additional information, but there could be more information forthcoming about situations like that one. That's an interesting question. So one of the major aspects of the ETS is the requirement that employers create a written COVID-19 prevention program. And for California employers, this will sound somewhat familiar because there's already a requirement that California employers have an injury illness prevention program, an IIPP. And that is not COVID specific. In fact, it predates COVID and will likely continue after COVID. And this is sort of a COVID specific COVID-19 prevention program that can be incorporated into the IPP or can be maintained as a separate document. We are recommending that people create a separate document so they don't have to redo their IPP, hopefully after the pandemic passes, or at least some of the requirements in the ETS pass. One of the things that's helpful, we thought we would just flag, is that Cal OSHA has put up on its website a model CPP that shows some of the things that should be covered. The model is not one that could be easily incorporated into a CPP necessarily for our business, but it does provide some insights into the way that Cal OSHA is looking at the regulations and interpreting them. So let's look at what a written COVID-19 prevention program must entail. I'll cover some of those portions, and then Marie will cover some others. One of the major aspects of the CPP requirement is a system for communication. And that's communication not only with employees, but also with others who come into the work site. And there are essentially four major parts that are a part of this communication requirement. One is that all employees need to be asked to report to the employer without fear of reprisal COVID-19 symptoms, possible COVID-19 exposures, and possible COVID-19 hazards at the workplace. And that requirement makes a lot of sense, right? And it's important that we have our employees are willing to come forward if they are experiencing symptoms or have had close contact, or willing to alert employers to potential hazards at the work site. The second is a description of the policies for accommodating employees with medical or other conditions that put them in increased risk of severe COVID-19 illness. And this is something that I think most companies that have employees, back at the workplace probably already have in place, but it's important that companies have a process for engaging with employees who may need an accommodation or have other needs due to their medical conditions. The third is to provide information about access to COVID testing, and we'll talk about this a little bit later in the webinar. COVID testing is not required by the ETS except for in certain circumstances, including when there's been a COVID-19 outbreak. And I saw that in our question and answer portal, we have a good question about what constitutes an outbreak. There actually are two types of outbreaks that are defined in the ETS, and we'll cover both of those, an outbreak and a major outbreak. And we'll touch on what constitutes an outbreak and what constitutes a major outbreak a little later in the webinar. And then the last one is to communicate information about COVID-19 hazards in the workplace. And the thing that's interesting about this requirement is it isn't just communicating those hazards to employees. It's also persons and entities within or in contact with the employer's workplace. And so this could include customers, suppliers, employees of other companies that come into the workplace. And I think that puts an interesting burden on companies, how they're going to be able to provide that information. And we can talk a little bit about that. So we touched on already this idea of identifying and evaluating COVID-19 hazards in the workplace. And that's a specific requirement within the ETS. And the ETS spells out exactly what a business must look at. And so in conducting and identifying COVID-19 hazards, businesses should look at interactions, areas, activities, processes, equipment, and materials. And when they're doing that, they need to think about all people who enter the worksite. And again, this relates back to the issue that we touched on earlier. This can be employees, but this can also be employees of other entities, members of the public, customers or clients, or independent contractors or suppliers. And so a company needs to think about all the hazards that individuals who enter their worksite encounter. And as we thought about this at 650, we've really thought about it in sort of a couple of different buckets. The first being instances in which employees or individuals come in contact with other individuals. So times where people may cross each other within 6 feet or may come into contact with other individuals. And then we've talked about and thought about times that individuals may come in contact with material or equipment that could pose a hazard. So when conducting this identification and looking at these different areas, there are also some additional requirements. And those are that employers must treat all people who enter the worksite, regardless of whether they're having symptoms or have a negative COVID-19 test, as potentially infectious. And this, I think, accounts for the fact that there are asymptomatic people out there and is really meant as a safeguard. And so when employees are looking at interactions and hazards, they need to treat every person who enters the worksite as if they could be infectious. The identification and evaluation must also include places and times when people may congregate or come in contact with one another. And so as a company is evaluating hazards, they need to think about times when employees or individuals within their worksite are interacting with each other. And this could be during meetings or trainings. This could be at the beginning of the day or the end of the day, at break times, at lunch. And then they need to think about where those interactions are occurring. Is it at the entrance to the building? Is it restrooms, hallways, walkways? Is it in the kitchen or a break area? Where are people congregating? Where are those hazardous interactions occurring? In addition to identifying, and this is, I think, a really important element of conducting this identification and evaluation, is employers must involve employees and authorized employee representatives in the process of evaluating hazards. And this also relates back to the communication point that we touched on earlier, that it's important that employees play a role in identifying potential hazards. You know, the employees probably know best what they do during the day and what they come in contact with. And so when a business is creating its COVID-19 hazard identification worksheet, it needs to be involving employees and authorized employee representatives. Finally, as a business conducts this identification and evaluation, it needs to do so in a written form. And in the model CCP that Cal OSHA has provided, the identification of COVID-19 hazards worksheet is included as Appendix A. And so this evaluation needs to occur and be put in writing and then included with Appendix A. And by including it in the CPP and providing that to employees, employers will be meeting their obligation to inform employees about the hazards in the workplace. Another requirement within the CPP and within the ETS is that employers implement a process for screening employees. And this is probably not a surprise to California businesses who have been required to screen for some time. The ETS, though, gives, I think, some additional detail that's helpful. It says that employers may ask employees to evaluate their own symptoms before reporting to work. And we've seen that as we've helped companies with the return to work. There are many companies that are having employees fill out a screening questionnaire at home before they leave for the office. And that is contemplated here under these ETS as a proper way to screen. Also, if employers decide to conduct screening at the workplace, they must ensure that face coverings are used during screening and that temperatures are measured with a non-contact thermometer to the extent they take temperatures. And so that screening requirement is an important one for businesses, especially that have not returned to the office and are contemplating the steps that they need to take. They need to figure out how they're going to screen employees, and they need to document that in their CPP. Interestingly, testing is a little bit different. Under the ETS, testing is not required except for in certain circumstances. And this relates back to the question that we had earlier about COVID outbreaks. So testing is required when there's been a COVID outbreak at a business. And a COVID outbreak is defined as 3 or more COVID-19 cases in an exposed workplace within a 14-day period. It's a pretty low bar, especially for workplaces that have a lot of employees. But if there are 3 or more cases within a 14-day period, that constitutes a COVID-19 outbreak, and there are requirements that employers provide testing for their employees. Another instance when testing is required is when there is a major COVID-19 outbreak. And that's when there are 20 or more COVID-19 cases in an exposed workplace within a 30-day period. And when that barrier is met, there are also testing requirements and frankly, more extensive testing requirements where employers need to provide testing for their employees. But in other circumstances, outside of an outbreak or a major COVID-19 outbreak, typically testing is not required by the ETS, although it may be required in some local areas. Another thing that will not come as a surprise to businesses that are already open are the physical distancing requirements. Obviously, Cal OSHA is calling this physical distancing instead of social distancing. All employees shall be separated from other persons by at least 6 feet. And that's pursuant to CDC recommendations. There are some exceptions. When an employer can demonstrate that 6 feet of separation is not possible, and except for those momentary exposure while a person is in movement. And I think that contemplates, walking past someone in the hall or in doorways or in restrooms or other places. I think OSHA realizes that it's not possible to keep people 6 feet apart at all times. But I think inherent in these exceptions is the idea that this is momentary, that these are moments when people cross each other. The Cal OSHA in the ETS also provides some methods of physical distancing that businesses should consider as they're thinking about how to enforce physical distancing in their office space. One of those is telework or remote work arrangements. Obviously, if people are working at home, they're not coming within 6 feet of their coworkers, typically. Reducing the number of persons in an area at one time, including visitors. A lot of businesses are not allowing visitors into the workplace to reduce numbers. Visual clues such as signs and floor markings is something that you see in a lot of businesses, including grocery stores and other places. Staggered arrival, departure, work, and break times. A lot of businesses have realized that one of the times when there are significant interactions is when employees report at the beginning of the day, especially if there's screening going on at the workplace. As employees congregate and are waiting to be screened, that can cause challenges for physical distancing. And so many businesses are staggering start times, they're staggering break times to try to lessen the number of people that are in different areas within the office. And then adjusted work processes and procedures. So some things may need to be done more slowly or in different ways in order to allow physical distancing. When it is not possible to maintain a distance of at least 6 feet, employers should assure that individuals are at least as far apart as possible.
And Ryan, we do have a question. It's related to the distancing indoors, or I guess just the indoors in general. Are there any requirements or implementation of IAQ or indoor air quality required?
So that's a great question. And the ETS actually do have a provision on ventilation, and that's a big issue. And I think we can look at that and put it in the chat, but there's a provision that essentially requires that companies assure that their ventilation system is functioning at the highest level possible and that they are assuring the delivery of as much clean air as possible. And so ventilation is a part of the requirement for the CPP. So yeah, great question. Thank you. The next section we're going to talk about just very briefly is face coverings. And I think this is an issue that everyone at this point is very familiar with. The ETS says that employers shall provide face coverings. So it's the employer's responsibility to provide face coverings and ensure that they are worn properly over the nose and mouth. And I think we've all seen people wearing their masks, down around their chin or just over their mouth. But the requirement is that employers not only provide the face coverings, but ensure that they're worn properly. And they must be worn when indoors, when outdoors, and less than 6 feet from another person. So when you're not physical distancing, and where it's required by CDPH and other local health departments. There are some exceptions to this mask requirement, and this is a question that we've received quite often in helping businesses with the return to work is, do I have to wear the mask when I'm alone in my office? And here under the ETS, that's listed specifically as an exception. When an employee is alone in an office, they're not required to wear a mask. When they're eating and drinking at the workplace, provided that employees are at least 6 feet apart and outside air is supplied to the area. And so that's something that we've had people ask about. Well, what about people are eating in the kitchen or other places? I think as a rule of thumb, people should try to stay at least 6 feet apart and be in an area where the amount of outside air is maximized if they're not going to be wearing a mask while eating. Employees wearing respiratory protection, employees who cannot wear face coverings for various reasons are also accepted. So that covers the face covering requirement. And now I'm going to turn the time over to Marie, who's going to talk about some of the other provisions of the ETS.
Okay, thanks, Ryan. So in addition to the rules that Ryan has already sort of walked us through, a lot of which probably seem familiar to people because they're variations on what we've already seen in the past, we also have under the ETS a lot of specific guidance for what happens when you exclude an employee from the workplace because they either they've tested positive for COVID or they're subject to an isolation or quarantine order. So specifically, you're now required under the ETS and to have written into your CPP rules that exclude any employee from entering the workplace if they have a positive test, if they're subject to an isolation or quarantine order. So people that would fall into that category are people who, say, for example, fail the screener because of their symptoms or because they're subject to an isolation order because they've been in close contact with somebody who's tested positive. So these are the people that would fall into the category of excluded from the workplace. And one of the things that has caused, I would say, the most upset about the ETS is this benefits requirement. So under ETS, basically Cal OSHA is saying if somebody is excluded because of the ETS, and otherwise they're available to work and able to work, you have to still provide to them their benefits, including their earnings, their seniority, their job status, and any other rights or benefits they're entitled to. So that means that they can't lose seniority because they're not attending work while they're subject to a quarantine order, for example. You can't dock their pay, all of those things. However, one thing that you can do is you can rely on exhaustion. So if an employee who's excluded from the workplace is entitled to other benefits, so say if they're entitled to federal relief because of their situation, you can deduct that from their pay and give them the remainder of the pay. What Cal OSHA hasn't done, which would be helpful, is explain how you're supposed to know what other benefits they have received if those benefits aren't flowing through your organization. So there's still definitely a lot of gray area there in terms of how to actually implement this rule. But if you are looking at situations where you have excluded employees because of COVID, you do need to make sure that you're keeping them on payroll, that you are still providing them any other benefits. You can require them to exhaust, for example, their paid sick leave before you go into what we'll call like exclusion coverage. But you cannot essentially take away any benefits because of the exclusion order. So the question then becomes like, how long are they excluded? And that's where it depends on whether they're a symptomatic or asymptomatic case. So if the person is excluded because they have COVID and they have symptoms, they cannot return to the workplace until at least 10 days have passed since their symptoms first started. And they haven't had a fever for at least 24 hours without the use of fever reducing medication. So if they've taken a Tylenol within the last 24 hours, they have to wait another 24. And then also their other symptoms have to have improved. So that's for people that experienced COVID symptoms. For people that did not experience symptoms, but did test positive, they have to remain excluded until they have gone 10 days since their test and they still haven't developed symptoms. Or if they did develop symptoms, they have to then meet the symptomatic requirements. So just put them back into that other category. And then for those people that are excluded purely because of an isolation or quarantine order, they themselves neither tested positive nor had symptoms, you just rely on the original order. So if there's a public health directive that says, if you've been in close contact, you have to self-quarantine for 10 days, you have to wait till those 10 days expire. So essentially, that is sort of how you control who can and can't come into the workplace. I see that there may be a few questions in the chat, so I'm just going to look over there really fast. Okay, so if there's a question that's asking whether, so after they've, exhausted their PTO and FFCRA has expired, so the federal benefits aren't available, what if the person cannot work remotely because they are ill? So this goes back to the question of if not for the COVID-19 exclusion, they are otherwise available and able. So if the reason they're not available is because they are ill, it's not just because they're excluded because they had COVID or have COVID, then, and this is where, right, we're gonna have to wait and see, but according to the FAQs, it would appear that in those situations, those employees are not protected under this part of the ETS because they're not able. So, other benefits could still apply. There's also some local regulations you'd want to check against in a lot of counties in California. But under the ETS, this specific portion would not be applicable in that situation. Okay. Ryan, if you want to add
Yeah,
to that.
I was just going to say there's another interesting question here about the quarantine period. And as you and I have discussed before, the CDC recently reduced its recommendation regarding quarantine to 10 days or 7 days with a negative test. And the question is, do we expect Cal OSHA to change to be consistent with the CDC? And I think that's probably Mike and Paige's question, maybe similar. What about employee proof of testing? That may be a similar question. What do you think about that? Do you think that we could see, and Adrian, I'm interested in your thoughts as well. Do you think we could see some updates here to these standards to make them conform with the CDC?
Yeah, the great thing being that that difference happened within days of the ETS being being published. So that's an example of, one of the weaknesses of the ETS, I would say. And Adrian, I'll defer to you here because I think you have a slide about future updates in terms of what we expect.
Yeah, there could definitely be some future updates to update that policy. There should be a stakeholder meeting in December to discuss this, but we could definitely see an update there. And in response to the negative test, the ETS specifically says that companies cannot require a negative test to allow employees to return to the workplace. So that is one requirement that, according to the ETS, companies can't ask for. So that might conflict with the CDC guidance of shortening the quarantine period, but I guess we'll see how the ETS is updated based on the new CDC guidance.
Thank you. Okay, I think that would, I do see that there's an IRS question regarding the 2/3 rate and how that affects category 4. I'm going to reserve that for the email because I want to check myself before I explicate on that too far. So we'll reserve that one for the email if Jesse can just note that in the chat. Okay, so after you have a COVID-19 case, or when you have a COVID-19 case on your work site, you're required under the ETS to both investigate that case and then to go through certain responses. So the investigation, you have to verify their case status, whether they're positive or negative. You have to record so with your investigation, everything you do has to be recorded. So in terms of what's involved there, there's a list here of the specific pieces of information that you need to include. There's also a model investigation report that's included as part of the model CPP. And we also have created one in the tool set that Ryan's going to show to you in a few minutes. With the investigation, one of the important things to note is that you do have to complete an investigation even if the person who became a COVID-19 case is not an employee, but you become aware that they either, were actively on your work site while they were positive, or while they were COVID positive, or in the symptomatic high risk period. So for example, if a local health department contacts you and says we're doing contact tracing and John Doe was on your premises on this date, that is considered to be a case that you now have to investigate as a workplace. So this covers both your employees and non-employees who are at your work site. So keeping that in mind, you have to go through the investigation process. You then have to, within 24 hours, notify any of your employees or non-employees who were at the work site who are were potentially exposed to the person. And then you also have requirements to notify your local health department, keeping in mind that that's the health department of the county that you are located in. You may have employees who live in other counties but work in your county. So your responsibilities in terms of notification are to your local health department. And then as part of this investigation, as you're giving these notices, you have to keep in mind that you're required to keep the personally identifying information about any COVID case confidential. So you're treating all of this information as confidential medical records, which does mean, among other things, that you need to store these records separately from the general employee file. So anything with that medical information is not supposed to be stored in the same place as generic employee information. It needs additional confidentiality controls. And then also, for anyone who is potentially exposed, this goes back to what Ryan was talking about in terms of testing. Um, Not only are you required to offer free testing to those employees, you have to offer it to them during work hours, and they have to be compensated for their time. So you can't say, okay, take an hour break and go get tested. You have to compensate them for the time that they spend during the work hours being tested. And then just keeping in mind that also with that notice, when you're looking at who you have to give it to, what they're really interested in is people that were potentially exposed during the high risk exposure period, which the ETS does define. High risk exposure period for symptomatic individuals starts 2 days before the symptoms began and goes through 10 days after the symptom onset date. And again, has the 24 hours since the fever requirement. Or for asymptomatic individuals, the high risk period is 2 days before the positive test until 10 days after the date that the specimen was collected from them. So that's part of the investigation process, is you have to find out symptom onset dates, you have to find out test dates, you have to find out all of those things and categorize them so that you know who you are then going to have to notify as being potentially exposed. Just checking the questions really fast. Okay, there are contractors. I see there's a question about managing on-site testing requirements. There are contractors available to manage that process for an employer, keeping in mind that there are requirements for any on-site testing, that you have to maintain mask requirements in the testing spaces. You also have to maintain as much confidentiality as possible. So conducting the tests, in public spaces is not something you should be doing. So if you are engaging a contractor to provide employee testing, just keep that in mind and think through where you're going to set up the on-site testing to make sure you maintain as much confidentiality as possible. And then in terms of doing follow-up doctor's appointments, we have a question asking whether the employee needs to cover wages during the time they're out. There's nothing in the ETS that specifically says you're required to do that. What they talk about specifically is the test itself and covering them for the time that they are in, that they're being tested if they were exposed at the work site. So there may be other rules and regulations that may impact the answer to that question, but as far as the ETS itself, that's not one of the requirements. Okay, I think we're ready for the next slide. Okay, another thing that is required through under the ETS is that you provide employee training. So a lot of the things that we've been talking about in the webinar so far are going to be included as things that you have to train your employees about. So you have to train them about your COVID-19 policies and procedures. You also have to train them on information related to the benefits that are available to them related to COVID-19. And this is the one that I find the most interesting. You're required to train your employees about facts related to COVID-19 and the methods of physical distancing and the importance of hand washing and the proper use of face coverings. So this is really interesting. There has been a lot of conflicting information that, throughout the term of the pandemic has come out at different times about the importance of different aspects of, how we're trying to get a handle on the pandemic. Um, so you're not free to decide which facts you want to share with your employees as part of the training requirement. The ETS actually gives specifics about what they want you to include in that training. So for example, the importance of hand washing. The ETS specifically says that you need to train your employees about the importance of washing their hands for at least 20 seconds. So, they specify that there, and about the fact that, just using antibacterial on your hands if your hands are already soiled. So say you have, something on your hands and you just put antibacterial over that, it's not sufficient to be considered clean at that point. So there's a lot of like very specific pieces of information that you have to train your employees on. I actually find this helpful in the sense that you're not being asked to make those judgment calls yourself as a company and then potentially, get into a situation where Cal OSHA disagrees with the information you decided to share. So, you know, as you go through the ETS and as you prepare your CPP, you need to put these pieces of information in there. It also talks about I mentioned the proper use of face coverings. We see a lot of improper uses. I know everybody's seen it every time they've gone out, people, at the cash register with their mask down below their nose and different things like that. So you really do have to train your employees on these specific pieces of information. Adrian.
Oh, that's great.
Maybe before we move on, Marie, we could just get you with one question about training. And let me just say, I really appreciate all the great questions we're getting here. We're just having, they're flowing in and we're trying to answer as many as possible. But I thought this was an interesting one just on the subject that you're currently on, Marie. It says, what kind of training does this require? The sample written protocol the state posted included a type of sign-up sheet for training with employee signatures as an example. Should we consider that the standard for training?
That's a great question. So far, in terms of any specifically recommended trainings, we don't have anything that would go towards the record keeping requirement. That's actually on the next slide, keeping record of whatever training you do provide to your employees. So that could be considered a best practice in terms of the record keeping side. As far as the training itself goes, Cal OSHA has said that they're going to do a training at some point via a webinar. We're also planning to do some. I would say, in terms of what the training should include, I would recommend going a step beyond just a written policy, just because we are all aware of the fact that disseminating a written policy and having people sign that they read it is sufficient for certain things, but not others. So think of it, the way you think of things like sexual harassment training. You really want to make sure your employees are complying. And so giving some sort of we're not looking at in-person trainings these days, but some sort of virtual training where there's an actual trainer talking to your employees, walking them through these requirements. That's really what I would say is your best practice. And then having some kind of record, like what you see in the model, is what you want to do to verify that you've taken that step.
Yeah,
That's right. And
go ahead, Adrian. I think that's a nice segue into your section is.
yeah. Well, and I just wanted to add too that we've already seen, this was prior to the implementation of the ETS, but we've already seen Cal OSHA issue citations and apply penalties to company solely for the failure to keep documentation with respect to their training. So the company provided the training, but they didn't keep adequate documentation of the date was offered, the employees attended, and the substance of the training. And Cal OSHA issued a citation and penalties for that.
Yeah, and just a couple of other record keeping items if we want to go to the next slide on that. In addition to records of your trainings, so really of every step you take to implement the CPP, you need some sort of written record. And for that, a lot of times the written CPP itself is your record, because a lot of the things that ETS says you have to do are establish a written policy that does all of these different things, right? You also need records of any case you've investigated, that you make available to employees and to their representatives if requested, keeping in mind that you have to, redact any personally identifiable information when you do that. You also have to record any testing that you've done as a company, and do it in such a way that, again, you protect employees' confidentiality as much as possible. And the only time that you don't need to worry about redacting information is if when you're required to share information with local health departments or is otherwise required by law. If they require an unredacted version, you can give an unredacted version to certain agencies. And also keeping in mind that with reporting, you still have your general Cal OSHA reporting requirements. So if you have any COVID-related serious illness or death among your employees that occurred either in the workplace or in connection with employment. So if an employee was exposed at work and then suffered serious illness or death, those you're required to report to Cal OSHA immediately. So those are the main reporting requirements that are involved in the ETS.
Great, thank you so much. And I just wanted to talk at a high level about some of the compliance issues and penalties we're seeing with respect to the ETS. So the ETS went into effect on November 30th, and we'd only seen drafts of those standards 10 days prior, but it was adopted and went into effect immediately, which means Cal OSHA can enforce those, can already enforce those. And in their frequently asked questions, Cal OSHA has said that they will consider an employer's good faith effort in working towards compliance, but some aspects of the ETS, like reducing hazards and implementing testing requirements during an outbreak, those are considered essential. So companies might not see any flexibility or lacks of applying citations and penalties with respect to those requirements. We have seen Cal OSHA violations of the ETS are subject to Cal OSHA's general penalty structure. And under that structure, there are 5 different types of penalties. And these are explained more in the slides, but they start from regulatory, which is record keeping, general violations, which don't relate, or they relate not to the health and safety of employees, serious violations, which are ones that have a realistic possibility of death or serious physical harm that comes from the actual hazard created by the violation. And that's where we're seeing the bulk of COVID-19 citation penalties. So if a company is failing to keep records, like for a training, that would be a regulatory. If they're not having the training, that would be a general citation. But really any hazards or testing or exclusion from the workplace requirements, those are falling under the serious category, which means that they are subject to higher penalties. So these are the maximum penalties for each violation of Cal OSHA requirements. So you'll see that for serious penalties, the maximum is $25,000, and that's per citation. And so based on the documentation we've seen from Cal OSHA from August to November of this year, so prior to the implementation of the ETS, we've seen companies that are investigated for COVID issues having an average of 3 citations for investigation. So that would mean $25,000 is the maximum per citation. And companies have received up to 10 citations per investigation, or as few as 1. But $25,000 multiplied by the number of citations companies are getting from that specific investigation from Cal OSHA. Willful and repeat penalties, the fines are very high for those. And those are ones that were very negligent or kind of reckless by the company, or repeat of penalties or citations the company has already had in the past. And this is will show you, based on historical Cal OSHA COVID-19 penalties and citations, more than half of them are in the serious category. So that has a maximum penalty of $25,000. But also, this is from other Cal OSHA regulations. There are a lot of general and regulatory citations issued as well for companies who have foot faults about not keeping the kinds of records Cal OSHA requires. Those records don't contain the requirements that Cal OSHA mandates. So there are a lot of those specific requirements in the new ETS that companies need to be aware of. Though they might seem minimal or trivial about what has to be in a specific record, Cal OSHA can issue citations for failure to include exactly what they say in the record that must be maintained by the company, as well as for other serious violations by not providing a safe workplace. Oops. So this is to give you a flavor of what we might see under the ETS. Cal OSHA citations related to COVID started in August, and there were only 12 citations issued and penalties, but they have really ramped up from there. So in November, even not the full month of November, we've seen up to $450,000 of proposed penalties applied to companies, and we're only expecting that number to increase exponentially based on the new ETS and additional enforcement by Cal OSHA. So companies need to be on guard because the penalties are high, and there's a serious risk of citations, as well as an unsafe workplace, which can be detrimental to a company. So since August, we've seen 1.6 million of COVID-19 related penalties assessed by Cal OSHA. The mean of those penalties, so the mean applied to a company is $29,000 of possible penalties. Those can be appealed by the company, and we don't have the final numbers of the final penalty decided, but at least proposed by Cal OSHA, an average company that's investigated is receiving $29,000 of proposed penalties. Penalties have been as low as $475, and that was for failure to keep the accurate records required by Cal OSHA. Or one company with different locations has been subject to over $300,000 of penalties by Cal OSHA. So this is a serious matter for companies, and there are serious penalties involved. So that is kind of underlying the importance of complying with these Cal OSHA requirements in the new ETS. Here's some information. Most of the investigations and inspections by Cal OSHA come from complaints. You can look at that later, but just wanted to wrap up what's next. So the standards board that adopted these requirements has noticed that there are a lot of issues and a lot of questions that are unanswered because of the new ETS. And so they've requested that Cal OSHA form an advisory committee consisting of representatives from labor and management and other occupational and health safety and health professionals to work on improvements to the ETS. And they plan to Cal OSHA will hold a stakeholder meeting this month. And then after that, the advisory committee will discuss how to improve the ETS and clarify provisions that may be unclear at this point. So this isn't final, it is final now, but we might see additional changes based on those stakeholder meeting and advisory committee meeting. There are some additional resources from Cal OSHA that you can find on this slide. And I'll turn it over to Ryan to talk about some solutions for companies to comply with the ETS and all its complexity and hopefully avoid those penalties.
Thank you, Adrian. Now that you've heard kind of in detail about many of the provisions in the ETS, you may be asking, what do I do to comply? And we've been thinking about that at 650. We have been helping businesses with the return to work, and many of our clients have come to us with questions about the new ETS and these Cal OSHA regulations. And so we thought it might be helpful. We'll just, as an example, show you how we have approached compliance here. I think there are other solutions out there as well, but we thought it would be helpful just to show you what we're doing here at 650. So we have a document generation engine, and we have used that engine and experts on these new ETS to create a customizable CPP that a company can walk through a series of questions. And as you can see on the screen, these are some of the questions, and fill out answers, and it will generate in Word a CPP that a company can then take and then further edit to the extent it needs to help it with the document portion of the requirement. And as was touched on before, a lot of the requirements here not only require a company to take action, but it's important that the company then document those actions. And so the CPP can help with that. In addition, we have used our engine to create a customizable COVID-19 hazard identification worksheet and also a case investigation form. And so after a company walks through the questions, it then generates a document that incorporates their answers and helps them to create a CPP that we think addresses the issues that are raised in the ETS. We are also in the process of creating an ETS assessment form that will help companies who maybe are thinking, I don't really know where to even start, to think through the issues that need to be covered in their CPP before they generate the policy. And so it'll ask a series of questions, and then it will also provide considerations that someone could kind of use it to prepare themselves to create the required CPP. And that's how we've tried to use our document generation engine and the resources that we have at 650 to help businesses to comply with these new requirements. I know that we scheduled this webinar for an hour. As you can tell, Adrian, Marie, and I are excited about these new Cal OSHA ETS, and we got pretty deep into it and are now 5 minutes over the hour. But I think it would be helpful for us to just take a minute and answer some questions. And there were a couple that jumped out at me, and I'll do my best to just start. But we first want to thank everyone who's joined us for the webinar. We understand if you've budgeted an hour, but we'll maybe take some additional time to answer questions for the next few minutes. And if we can't get to all the questions, we'll try to answer them offline. Two questions that I saw online. One was, can you fulfill the mask requirement by reimbursing your employees for buying their own masks? That's an issue that I haven't seen addressed in the FAQs or anywhere in the regulations. It does say specifically that employers have to provide masks. And so I'm not sure. I think that that's an interesting question. And to be honest, I haven't seen anything that would answer that directly. I think the safest thing probably would be to go to a CVS or somewhere and buy disposable masks and have them available at your workplace. That seems to directly meet the requirement, but I could see an interpretation where reimbursing employees who bring their own masks could potentially meet the requirement. I just think it's unclear at the moment.
And I would second what Ryan said there, especially because a number of companies that we work with, we provide them with a COVID-19 reimbursement policy. And so if your policy covers, for example, mask reimbursement, that would appear to meet the requirement, but also the real purpose of that requirement is to make sure there's never anybody on your premises who's your employee who's sitting there like, oh, sorry, I just don't have one today. So even if you're planning to use your reimbursement policy as the way you meet the requirement, you should absolutely still have masks on hand.
There was also a question that I saw about break rooms and how they seem to be required under certain California requirements, but under the Cal OSHA hazard identification, they could be problematic. And I think that that's a great point. You know, a break room certainly is somewhere where you could have interactions between employees. You also have a lot of things that employees would touch in there, potentially refrigerators and other things. And so I do think it's an area that businesses need to think through. And I think signage and stickers and also just dispersing information about the break room in a CPP could be a good way to go.
I'll chime in on one that I was looking at. Somebody asked, when offering free testing, our employees have health insurance. Do we tell them to go to their personal doctor or clinic or find a free government testing place? So this is something that the FAQs don't address directly, but I would say that if you direct them to go to a free government test site, that would not appear to meet the requirement that you provide testing, because that's government provided testing, not company provided testing. I would say that this is a good opportunity to reach out to your insurance provider and talk to them about the ways that testing is covered for free under the insurance, so that then you can make your CPP, your written policy, reflect the actual process that the employees need to take, so that when they do follow the instructions in your CPP, they're getting a test that's done in such a way that the insurance provider will cover it. So I would double check with your insurance provider on what those steps need to be. And then for it to actually meet the requirement of the ETS, yes, it does need to be one that they obtain from somewhere other than a free government provider. Not that they can't go to one, but that you need to provide them with another option other than the free government test.
Thank you, Marie.
I can answer a couple about the violations and citations. So citations are typically, somebody asked, is a violation per person? So if there are 6 people in the office without a plan, or is it just per violation? And the citations are per violation. So failing to have a CPP would be 1 violation. It's not applied per employee that would be affected by it. And then also there was a question about, are we seeing mask enforcement issues being cited as serious violations? And yes, those would be considered serious violations that are applied with a penalty, a more serious penalty than the other types of violations. And as well as the 2 differing requirements of notification under SB 685 and the ETS, companies are expected to comply with both. And so to the extent there is a more comprehensive requirement, companies should comply with that, which makes it a little frustrating and confusing that there are two different standards, but companies have to comply with both. So in one case where you only have to provide notification to affected employees or to the whole workplace, the company should err on the side of the more comprehensive and provide notice of exposure to the whole workplace of all people who are in that work site with the infected employee.
And I'll just weigh in on that. One of the nice things about that in terms of like providing more notice than otherwise, we have seen a number of situations. We have a return to work toolkit where we work with companies. And there are situations where employees don't do what they're supposed to do. You train them, you do all the things you can do, but they still, for example, don't fill out that screening questionnaire one day. And so you don't know they were in the workplace because they didn't fill out their screener. If you give notice to everybody, that person who knows they broke the rule now has notice and can go get tested and hopefully maybe help prevent another outbreak. Whereas if you gave the more limited notice, you might miss some people who you're not aware were present because they broke a rule. So it's also just practically more protective.
Yeah, good answers. And man, great questions. I mean, it's awesome to see this many questions coming in. And I've even enjoyed in the chat, I think some people answering each other's questions and interacting. It's fun to have a community of people who are interested in this topic. Why don't we just touch on a couple last questions. One is about hazard identification. I think this is one of the most difficult areas, to be honest, of the ETS. If you look at the Exhibit A to the CPP provided by Cal OSHA and the model policy, it doesn't really give you a lot of guidance on the level of specificity. And I think our question here is, can I just say restrooms and for the time as ongoing, because people are using restrooms throughout the day? And and the question is that specific enough? And I think that really as specific as you can go is good, but at a certain point, I don't think that you can necessarily address every individual interaction that someone could have throughout the day for all of your workforce, especially if you have a large workforce. And so I do think saying restrooms are a place that people have interactions. It's also a place where people are touching different surfaces. We think that the potential for exposure is low because of the way that we clean the restrooms and because of signage. I actually think that that would probably be sufficient. But I think that that's one of the questions that's left open by the regulations, is the level of specificity that's required for the hazard identification.
Yeah, and I would just add to that with restrooms, it is sort of an ongoing, but also think through where you're thinking about using that sort of label for anything. There are other places where there's an ongoing hazard, but it's also higher at certain times. Elevators are a great example. Like, people use the elevators throughout the day, but they use them the most at certain times of day, right? When everybody's coming into work, when there's a shift change, when people are leaving work. So, those would be your high traffic times where you might need special controls that you would need to implement. So think about that. Like, yes, this is always an issue, but are there times when it's a particular issue?
Yeah, so these are great questions. We're almost 15 minutes over. There was a question in here. Someone asked, they said they had not worked with 650 before. What is the price for return to work? And I just wanted to say that, one of our missions here at 650 is to make legal tools more accessible. And so we often price based on company size, so that we hope companies of all sizes can afford our tools. We also create free tools for individuals. We call them our pro bono tools to help make the law more accessible for individuals and businesses. I just want to thank everyone who's joined us. In fact, we have a great question here at the end from Artesia Dupree, who says, are the Q&As going to be available? And I think we can work on doing that, but we've had great questions and participation, and we want to thank everyone who's joined us for the webinar. We hope you'll join us for future webinars. As Marie previewed, we're planning to do some training on Cal OSHA standards, and we'll also do future webinars on this topic. But we appreciate the time you spent with us today, and we hope this has been helpful and informative.